Unpopular opinion, but you know me, I'm here to give it to you straight. And that is that half the issues, maybe more, that you have with your ex are not legal issues and should not go back to court. They're really issues that are interpersonal issues, they're communication issues, they're boundary breakdowns. Your ex might just be a bad person, but none of that is going to get resolved or solved by a court. In fact, you'll go back to court, you'll put a whole bunch of rules and stipulations in place, and the only person that's going to follow them is you. So, if you're new here, my name is Taylor Wins. I'm a divorce coach. I'm a co parenting strategist. I'm also a licensed Minnesota family law attorney, and I'm a divorced mom of four. And I've been doing this co parenting thing for like 5 years. So, it's really crucial that you understand the difference between what should go back to court and what is just an issue of your ex, quite frankly, being toxic or sucking, that you need to figure out how to deal with and manage outside of the purview of the court that isn't going to do anything for you anyways. So first, let's break down what shouldn't go to court. Then we'll talk about how do you fix those things that the court can't solve anyways. Then we'll talk about what should go to court and how to articulate and work towards getting what you want out of the court and that venue. Okay, so what should not go to court? Number one, your ex talking to you disrespectfully, with a bad tone, telling you you're a bad parent, picking at you. That likely is not an issue that should go to court. The reason it shouldn't go to court, number one, is unless they're harassing you, the court's not going to give you any relief. And the other thing is because if you do go to court and you spend a whole bunch of time, money, energy, and effort getting an order that says that your ex shall not disparage you to the kids or allow other people to disparage you in front of the kids or what have you, it's not really enforceable. Because even if you can prove that they're disparaging you, what's your next step? You'll run back to court again and get another order and they'll get another slap on the wrist. Maybe the third or fourth time they'll get a fine. Maybe they'll pay some attorney's fees. But them being rude probably doesn't warrant going to court. Number two, they're inconsistent with rules, bedtime routines, what they feed the kids, how they manage when the kids get sick. None of that is resolvable by the court itself. Okay. So, say you want your kid to eat organic apples and the other parent thinks they should eat Cheez Its and Lunchables for every meal. You're probably going to lose that battle because unless your child has some sort of allergy, intolerance, medical condition that makes it where they have to eat a certain diet or a certain type of food, the court is not going to care about these, what they call differences in parenting style. They just don't care. Like if your child is celiac and the other parent is feeding them gluten, well, now we have a serious health issue. But organic apples versus Cheez Its is not going to cut it. So taking the person to court to enforce rules like bedtime or, because they're letting the child stay up till 11 p.m. and the child's 7 years old, who is policing that? Even if you get the order, who is policing that? Your 7 year old's not a reliable witness, right? So there's really not a lot to be done about the fact that the other parent is a subpar parent. Unfortunately, we have to look for larger issues and patterns that are going to move the needle when we want the other parent to change behaviors that they're undertaking. Next is the other parent not showing up for parenting time. Please, 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 please stop filing motions on your co parent because they don't show up for the parenting time. If they're not showing up for the parenting time and your goal is for them to have less parenting time, let them keep not showing up for the parenting time. Like it needs to go on for a longer period of time. It's not a situation where they don't show up for parenting time for like 3 weeks and you're like, they didn't show up or they don't come to Johnny's hockey or his football game or whatever. Okay, fine. Let them be a bad parent. That's their choice. That's their prerogative if they want to be a bad parent. But if they don't show up for 3 weeks, there's not a lot to be done about it. When it starts getting to 3 months, 6 months, and things like that, and now we're talking about, okay, should we be looking at a modification of child support, or you want to move away? You want to move 7 counties away, or maybe you want to cross state lines or something like that. Then maybe you want to go to court at that point because you have a history and a pattern of failure to participate in the parenting time. But just filing a motion about your other parent not showing up for parenting time because you don't like them and you think they're a bad parent is not the move. And the last one, I've seen this a lot recently, is they won't agree to a sport or an extracurricular that occurs only on your time and you to sign the child up for that sport or extracurricular. This is not legal advice, first and foremost. This is personal opinion, as somebody who actually is a co-parent. If you want to sign your child up for something that only happens on your day and the other parent doesn't agree to it, and you have an order that says sports and extracurriculars will be by agreement, I think the spirit of your order is likely that if it affects the other parent, you want them to pay for it, they're going to need to bring the child on their time, then no, you shouldn't sign them up if they don't agree. That should be a conversation that you have. But if you want to sign Susie up for piano on Mondays and Monday is your day, 52 Mondays out of the year, you have the right to do what you're going to do on your parenting time. Are you going to call your co-parent and ask them for permission to go to the park next? There's not any point, right? And spending all of this money and running to court and getting these orders and getting these directives. And now you've just got new rules and you've opened up a venue for your co-parent to file new issues and make more chaos, right? So where you can stay out of court because they're the other parent just being a bad parent, or because you're not communicating well, or the other person is just being controlling and you can avoid it, just avoid running back to court for every little thing. Save yourself time, money, headache, heartache, and everything that comes back with being in a litigation context. Now, let's talk about what you can do in some of these settings and circumstances where your co parent is doing things that are wrong or annoying or making them a bad parent, but you don't need to go to court over them. Let's just run back through a few of them. And I've kind of already alluded to it. But if the other parent is treating you disrespectfully, they're talking to you crazy when you have conversations, they're talking about you negatively to the children, or letting other people talk about you negatively to the children, there are a couple things that you can do. If they're talking to you disrespectful or crazily and you want that to stop, get on a parenting app and do not take calls. Do not allow them to talk to you in public. Don't take text messages from them, and only check their correspondence to you through the parenting app one time per day when the children are in your care. And then, of course, if the children are in their care and you want to be checking the app more frequently for information or updates about your child, you can do that. You might also consider having a conversation with your child or your children about how we talk to people. What is good talk? What is bad talk? How would you feel if I was talking like that about you to a friend or to a third party? Is that how we talk to people? And just teaching your children how adults should talk and how they should talk too about other people when they're not there, and talk to people, and empower your children when they're of an appropriate age and when they feel comfortable doing so to have language. I don't like when you talk about my mom like that. And you'd be surprised. They really will. They will call out that behavior because they know that it's wrong. Let's talk about inconsistency in routines and schedules and bedtime and all the things. Some of that you just can't beat. The other parent will do what they do on their parenting time, and some of it you need to just let go. If you have parents that you're co parenting with who are bad with routines, bad with schedules, they're letting the kids stay up too late, they're feeding them junk food, and they get back to you and they're a dysregulated mess, consider not doing anything on the day that they come back. As much as you want to go to the bounce house and the jump park and, to play sports or to do the things, if there's nothing scheduled that you're required to be at, let them transition and have downtime that day. They don't need to always have something to do when they come back to you. Where the other parent isn't showing up for parenting time, document, document, document. That is one of my most watched videos on this channel. I will link you to it. But if they're not showing up to parenting time, start building your case for why they don't need more parenting time when they come back on that 50-50 motion, why you're not alienating them when they try to claim that nonsense, and why when you want to move away because you got a new job making 60 more $1,000 per year, that you should be allowed to do so because you're not interfering with parenting time. They're not exercising it. And those are some things you can do to conquer things that are disruptive, bad, not working in your co parenting, but aren't yet at a level to run back to court. Here are some things where you may have grounds and should probably go back to court in a situation with your ex. Number one, we talked about if they're being disrespectful to you, that's not quite the level. But if they're harassing you, and look at your state's definition of harassment, if they're harassing you, if they're stalking you, if they're creating situations that are physically unsafe, if you've had domestic violence in the past and now they're popping up places and they're in violation of, or the parenting time between your child and the other parent is not just bad parenting because the kids are up till 11 o'clock at night on a school night, but it's unsafe or they're violating other things like the right of first refusal, then yes, you may need to go back to court. What is unsafe parenting time? Domestic abuse in the other parent's home, substance use, drinking drugs, driving unsafely with the children in the car, refusing to put them in car seats, and they're like, 2, 3, 4 years old. I've definitely seen that happen. Leaving the children unattended and they're too young to be home alone, or trying to skip over or beat the right of first refusal by not telling you, and you're finding out from the kids, oh, well, daddy was gone for 5 hours and I got left with this person that you've never met, or he took me to work and we were at work till 10:30 p.m. Things like that. Yeah, you may need to have the parenting time reevaluated and assessed if that is a regular occurrence in your co-parent situation when they're parenting your children. Other appropriate court facing issues are things like not paying child support, not paying unreimbursed and uninsured medical expenses, child related expenses for sports, extracurriculars, school fees, anything that's in the order that's being violated. You should probably go back and see if there's a remedy for that, especially if it's one where they're going to be in contempt, they could get fined and they owe you a bunch of money, or where they're doing something and you might be able to get attorney's fees. By all means, if it's serious, egregious, they owe you a bunch of cash, then yes, the court may need to get involved to enforce that and make some changes and some modifications going forward. Now, if you're going to go back to court for any reason, before you hire your attorney, before you re-engage them, you need to have done a couple things. Number one, like I said, is you need to have documented everything that's going on. Huge. You cannot skip this step. You need backup. You need receipts. Your word is not enough. Number two, you need to figure out how to compellingly and appropriately tell your story to anyone who needs to hear it. I have an entire workshop on this. I can give you more information about that in the description if you're interested in checking that out. But that is telling your lawyer the story in a way that makes sense to them so they can advocate for you. Or if you're self-represented, figuring out your writing skills and your style and how you're going to relate this information in an affidavit or a declaration that's going to be court facing and go to the court. And then the same if you have to involve yourself in any sort of evaluations or get a guardian ad litem appointed to you because of what's going on in your co-parenting situation. Then the last thing that I'm going to teach you here today is that if you're going to go back to court, you need to be able to utilize the Dear Aunt Sarah rule. The Dear Aunt Sarah rule is something I learned from another attorney in practice who shared with me that if you're going to go to court, you need to do it like you're talking to Dear Aunt Sarah. So if you were going to talk to your Dear Aunt Sarah about what was going to happen, you need to be able to identify exactly what's going on that's at issue. What has happened and why is that a problem? Okay. Once you've identified that, maybe 2 to 3 things, no more than 4, but like, what is the issue? And you want to identify, how do we resolve that issue? What should be the change? Should do a modification of parenting time. We should be ordering a reimbursement of the child support or other expenses. And then from there, why you think that resolution is most appropriate and fair given the circumstances. And you need to be able to communicate all of that in a very simple way, just like you're writing a letter to Dear Aunt Sarah. So there you go. I hope that was helpful for you today. If it was, make sure you subscribe to my channel so you never miss any updates from me about life after divorce and doing this crazy thing that we call co-parenting. Make sure you take the next steps, which would be putting these actual things into practice in your life. We'll see you in the next one. Take care.